1969 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်918မတ်တင် A applicant vs the Union of Burma respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Revision before ဦးကျော်စံဦး Judge မတ်တင် A applicant vs the Union of Burma respondent Code of Criminal Procedure Section 190 Initiation of proceeding Magistrate could take action against any person in the interest of justice in the course of the hearing of the case, whether Section 191 of the Code has any application. Hell, Section 190 of the Code of Criminal Procedure applies to the initiation of proceeding. The trial magistrate had already taken cognizance of the offense against the original accused under Section 190B on the police report with the police charge sheet and the magistrate having taken cognizance of the offense, it is right and proper that he should bring to justice all those persons, whether originally mentioned or not. It must be regarded that the trial magistrate took cognizance against the present applicant under the same clause of Section 190 with Clause B as he did against the original accused, the offense being one and the same, and the magistrate having cognizance of that offense, acting under Section 190B, has full seasons of the offense, since the state of initiation of the proceeding was over. The magistrate could take action against any persons in the interest of justice in the course of the hearing of the case of which he acts in full seasons. Section 190 has no connection whatsoever in such case, and consequently Section 191 of the Code has no application. Mountain vs. the State 11 LBR 398 FB Mounted vs. Mounted Jue 1940 RLR 676 refer to U La Nyon for the applicant, U Jiao Myin for the respondent. U Jiao San U, Judge, this application arose originally out of the criminal regular trial, number 49 of 1965 of the Court of the Third Additional Magistrate, Meithila, Usobatan, when in the course of the hearing of the defense, including the applicant as a witness for the defense, the magistrate took cognizance of the offense under Section 8(1) of the Essential Supplies and Service Act against the applicant and made her co-accused in the case, as shown in the diary order date the 8th December 1963, and released her on bail in the sum of Jet 2000 with 2 sureties for her appearance before the court, and fixed the case for further hearing of the recalled witnesses for the prosecution and the defense. Being aggrieved and dissatisfied with the order, the applicant took the matter up to the Session Court in Criminal Revision numbered 135 of 1965, stating that the trial court took cognizance under Section 191C of the Code of Criminal Procedure, but failed to comply with the provisions of Section 191 of the said code, viz. To inform the applicant that she was entitled to have the case tried by another court, but she was unsuccessful. Hence, this revision. The session judge held that since cognizance was taken by the court against the applicant in respect of the same offense as the police took cognizance, Section 191B of the Code of Criminal Procedure applied, and therefore the trial court was not required to comply with the provisions of Section 191 of the Code. Under Section 191 of the Code, the trial magistrate could take cognizance of any offense. A. Upon receiving a complaint of facts which constitute such offense. B. Upon a report in writing of such facts made by any police officer. C. Upon information received from any person other than a police officer, or upon his own knowledge or suspicion that such offense has been committed. Neither the government advocate nor the advocate for the applicant seem to be aware of the full bench decision in Ngachanda v. the State 1, which was followed in Mount Tat v. Mount Chitjue 2, Section 190 of the Code of Criminal Procedure applies to the initiation of proceeding. In the instant case, the trial magistrate had already taken cognizance of the offense against the original accused under Section 190B on the police report with the police charge sheet, and the magistrate having taken cognizance of the offense, it is right and proper that he should bring to justice all those persons. Whether originally mentioned or not, it must be regarded that the trial magistrate took cognizance against the present applicant under the same clause of Section 190, viz. Clause B, as he did against the original accused, the offense being one and the same, and the magistrate having cognizance of that offense. Adding under Section 190B has full seasons of the offense, since the state of initiation of the proceeding was over. The magistrate could take action against any person in the interest of justice in the course of the hearing of the case of which he was in full seasons. Section 190 has no connection whatsoever in such case, and consequently Section 191 of the Code has no application. As regards Section 191C of the Code referred to by the applicant advocate, the information or the knowledge or suspicion mentioned therein has reference to the initiation of proceeding in regard to the offense alleged to have been committed, and not to a later stage of the case. The trial magistrate action in the present case refers to a stage later than that when cognizance was taken of the offense, and therefore Section 190 1C does not apply. He could proceed against anybody who may afterwards be shown to have been concerned in the commission of the offense of which he has taken cognizance. The police asked the magistrate to take action in the charge sheet, particularly against the original accused, and the court, after hearing, took cognizance of the case against the applicant, as well upon the same police report under Clause B of the subsection 1 of Section 190 of the Code in mounted vs. Mounted supra, it was held after a magistrate has taken cognizance of an offense in one of the three methods mentioned in Section 190, he gets the seasons of the whole case and his jurisdiction to bring everybody concerned in the commission of the offense to justice is in no way restricted. In the circumstances, I decline to accept the submission of the government advocate as well as that of the applicant advocate that non-compliance of the provisions of Section 191 of the Code of Criminal Procedure by the trial magistrate in the case under consideration is fatal to the case. The provisions of that section has no application in this case. The application is therefore dismissed.